On the last day of August 1986, a Sunday morning, an Aeromexico DC-9 was descending toward Los Angeles International Airport. A small, single-engine Piper was flying in the same patch of sky above the suburbs of southeast Los Angeles County. They collided. Everyone on both aircraft died, and so did people who were simply at home in Cerritos, California, that morning. The National Transportation Safety Board investigated, published its findings, and the cockpit voice recording from that DC-9 was part of the evidence. You have never heard it. Under current federal law, you almost certainly never will, and that is not an accident of policy. By the end of this, you'll understand something most people who follow air disasters have never been told. There's a specific federal rule that keeps cockpit voice recordings out of public hands, out of news broadcasts, out of the record you can go and read. It's written into U.S. law. It has a date. And the road to it runs straight through a suburban street in Cerritos, through the lawsuits that followed, and through a fight nobody outside aviation law was really watching. The reason you can read a crash report but never hear the voices in it is a decision somebody made on purpose, and it's still standing. Ask anyone who remembers Cerritos and you'll get the same version. A small plane strayed into airspace it wasn't cleared for. It hit an airliner. Houses burned. It became the reason the government pushed hard for collision avoidance equipment in airliner cockpits and for transponders that report altitude on small aircraft. That version is broadly right, and it matters. The safety changes were real, and they were driven in part by what happened over Cerritos and by the 1978 San Diego midair before it. But that's the safety story. It isn't the secrecy story. And the secrecy story leaves less of a trace because that's the entire point of it. Start with what the record actually says. The NTSB's aircraft accident report on the Cerritos collision is a public document. You can request it. It lays out the sequence, the airspace, the radar picture, the probable cause the board adopted. 82 people died in total, including 15 on the ground, and that figure comes from the board's own accounting, not from a headline. The report describes a limitation in the air traffic control system of that era, and a small aircraft in airspace where it should not have been. The board named a cause. Nothing about that was hidden. What happened next, in the courts, is where the story turns. Because a disaster like this doesn't end with a report. It ends with litigation, and a lot of it. Families of the dead sued. So did people whose homes were destroyed. There were claims against the United States government over air traffic control and claims involving the airline. Wrongful death cases from a mid-air collision are among the most bitterly fought in American civil law because the money is enormous and the evidence is technical, and in a civil case, lawyers can ask for things. They can subpoena, which raises a question that had been sitting quietly in aviation law for years, unresolved. What exactly is a cockpit voice recording, legally speaking? Here's the shape of the problem. A cockpit voice recorder captures everything said in that cockpit and everything audible in it. Pilots talking to controllers, pilots talking to each other, pilots saying things that have nothing to do with flying, because it's a workplace and they're people, and then, at the end, the sound of them realizing, investigators need all of it. Pilots' unions had argued for years that if those recordings could be played publicly or handed to reporters or entered into evidence as raw audio, crews would start policing what they said out loud. The safety tool would poison itself. That argument was old. Cerritos gave it teeth. Federal law already restricted the NTSB from publicly releasing the audio itself. The board's practice was to release a written transcript, edited to strip out material it judged irrelevant to the accident, and to keep the tape. But that only bound the board. It didn't clearly bind a court. It didn't clearly stop a plaintiff's lawyer in a civil suit from getting the recording, or stop that recording from leaking once it entered the machinery of discovery. Aviation lawyers understood the gap. The pilots' unions understood the gap. And in the years after Cerritos, with cases like this grinding through the system, the pressure to close it grew. Now, hold Cerritos next to the other collision that haunted the same decade. In September 1978, a Pacific Southwest Airlines jet and a small plane collided over San Diego, and people on the ground died there too. 2 mid-airs over Southern California suburbs inside 8 years. The safety response to both is well documented. What's less discussed is what those 2 disasters did to the litigation environment. They produced years of civil actions, expert testimony, and fights over what evidence the families were entitled to see and hear. And that is the environment in which Congress eventually wrote a much harder rule. The rule arrived in the 1990s. Congress amended federal law governing the safety board so that a cockpit voice recording and its transcript are handled under tight statutory limits. The board may make public a transcript or a portion of it at a public hearing or when it publishes the accident report. The audio recording itself is not released to the public, and in civil litigation, a court may order discovery of the recording only under protective conditions, with the court in control of who hears it and what they may do with it. That's the mechanism. Not a cover-up in a back room. A statute, on the books, in plain sight. So here's what really happened. Cerritos is remembered as a collision that changed the equipment in airliner cockpits, and it did. But it also sits inside the chain of events that turned cockpit voice recordings from evidence the public might eventually hear into evidence the public is, as a rule, permanently walled off from. The families sued. The discovery fights were real. The unions pressed the argument that pilots would go silent if their last words could be broadcast. And the answer Congress landed on was to protect the recording almost absolutely and give the public a transcript instead. A written version, edited, no voices. And a transcript is not the same thing. Read a cockpit transcript and you get words on a page with timestamps. What you don't get is tone. You don't get how fast a voice was moving, or whether a pilot sounded confused or certain, or the half-second of silence before somebody said the thing that mattered. Investigators listen to the audio precisely because those things carry information. Then the public is handed the flattened version. That's not a small distinction, and it's the heart of why this law is still argued about by people who study accidents for a living. Which brings us to why it stayed out of public conversation. Nothing here was classified. There's no locked vault. The reason almost nobody knows this rule exists is that it was written in the language of federal aviation statute and litigation procedure, and it was debated by pilots' unions, trial lawyers, and a small federal agency. There were no hearings the public followed. The safety story got the coverage because the safety story had pictures, wreckage, grieving neighbors, and a clean lesson. The evidence access story had statute numbers. So the collision entered public memory as a story about airspace, and the part about who is permitted to hear the dead speak vanished into legal footnotes. There's also a harder reason, and it deserves saying plainly. Some of the strongest support for sealing these recordings came from the families of dead pilots and from crews still flying, not from a government wanting to hide failure. If your husband died in a cockpit, the prospect of his final seconds playing on the evening news is unbearable. That is a real, decent argument, and it's part of why the rule has held for decades, which makes this one of the harder cases this channel deals with, because the secrecy has a humane motive and a genuine cost sitting in the same statute. But the cost is real, and it keeps surfacing. When a major crash happens now, the pattern repeats almost to the day. Investigators listen. Officials describe what's on the recording in summary. Sometimes fragments appear in the press, sourced to people who aren't supposed to be talking. Then the argument starts again about whether the public is being told everything, and there's no way for anyone outside the process to check. The seal that was meant to protect the integrity of an investigation also removes the public's ability to verify how that investigation characterized its own evidence. Both things are true at once. So what's still unsettled? Quite a lot, and I'd rather say so than pretend otherwise. Exactly how much weight the Cerritos litigation carried in the drafting of the statute, compared with San Diego, compared with other crashes, compared with years of union lobbying, is not something the record cleanly resolves. Legislative history rarely credits one disaster. Anyone telling you a single collision wrote that law is overselling it. What the record does support is that the two Southern California mid-airs produced exactly the kind of civil litigation that exposed the gap, and that the gap was closed afterward. And the deeper question isn't settled either, because it can't be settled by a document. Should the public be able to hear what was said in a cockpit in the last minute of a flight it paid to be safe on? Pilots say no, and they have reasons that aren't self-serving. Some accident researchers and some families say the sealing has gone too far, and that a transcript filtered by the investigating agency is not the same as evidence. Both positions are held by serious people. The law currently picks one of them, and it picked it decades ago, largely out of public view, which is why Cerritos belongs in this series and not in a list of air disasters. 82 people died on a Sunday morning in a suburb, and the machinery that grew out of that morning quietly redrew what the rest of us are allowed to know about how people die in the air, not by hiding a report, by deciding in statute that the report would be the only thing you ever got. And the strangest part is that the decision was made mostly by people trying to do right by the dead. If this is the kind of history you want more of, the buried mechanism rather than the headline, subscribe, because that's the whole job here. Next time, we're going somewhere stranger. A 1979 industrial accident in a Soviet city where the official cause was contaminated meat, the hospital records were seized, and it took more than a decade before anyone admitted what had actually drifted over that neighborhood on the wind.